Hello, ladies and gentlemen, this is Mr. Vanderpool. Today we're going to be talking about the federal court system, including the lower courts like the district courts and the appeals courts, the appellate courts, and all the way up to the U.S. Supreme Court. It is the job of these courts to interpret the law. Now, one concept that is very essential to this federal court system, particularly the U.S. Supreme Court, is the concept of judicial review. So this was established in Marbury versus Madison. So what judicial review says is judicial review allows the courts to rule on the constitutionality of laws, giving the court the power to strike down or to reinforce policy. So this ability of the federal courts, particularly the U.S. Supreme Court, to be able to declare a law or a government action unconstitutional is called judicial review. And it comes from this case called Marbury versus Madison. So let's look at this case of Marbury. Now, this case involved an act called the Judiciary Act of 1789. This was the first act of Congress that was partially invalidated by the Supreme Court due to this judicial review. This act did a couple of things. It established a federal judiciary. Only the Supreme Court was established by Article 3 of the Constitution. The rest of the courts were established through this Judiciary Act of 1789. The Judiciary Act also created what's called the writ of mandamus. This was an order to the lower court to fulfill its duties. So it's basically the Supreme Court telling lower courts, you have to fulfill your duties. So what happened in Marbury versus Madison is you have Marbury. He wanted Jefferson, President Jefferson, to give him a commission that was given in the previous administration, which was Adams, which was the Adams administration. So what ended up happening is Marbury wanted the court, the high court, the Supreme Court, to use this writ and force the lower courts to go ahead and give this writ to him so he could have the commission. And so what happened is the Supreme Court went ahead and they heard the case. And ultimately what they decided was that this writ was unconstitutional. It violated the U.S. Constitution, therefore it was null and void, because the Constitution is the supreme law of the land. So ultimately what they decided, the Supreme Court decided, was that this writ conflicted with Article 3, Section 2 of the U.S. Constitution, which said that the Supreme Court has original jurisdiction. It hears the case for the first time only in certain areas. If you have a state suing a state, or if you have a case involving ambassadors, this is all in Article 3, Section 2 of the U.S. Constitution. For those cases, and those cases only, does the Supreme Court have original jurisdiction. But then John Marshall also reasoned that this writ actually gave the Supreme Court original jurisdiction on things other than these allowed cases that you could have original jurisdiction on. And because of that, this section of the Judiciary Act of 1789 violated the U.S. Constitution. It violated the supreme law of the land. So therefore it was null and void, because no law can violate the U.S. Constitution. Okay, so let's take a look at the court system and how it is organized. So the lowest court in the federal court system are district courts. They hear hundreds of thousands of cases a year. There's a trial by jury. Then you have appellate courts. There are 12 courts of appeals. There's a panel of 3 judges, sometimes more. No cases start here. They review district court decisions. So district courts are going to have original jurisdiction. They're going to hear a case for the first time. District courts are not going to have appellate jurisdiction. They don't hear things on appeal. Appeals courts will hear cases upon appeal. They have appellate jurisdiction. So it's important to understand that idea of appellate versus original jurisdiction. If a court hears something for the first time, it's got original jurisdiction. If it hears it on appeal, it's got appellate jurisdiction. Appeals courts have appellate jurisdiction and only appellate jurisdiction. District courts will have original jurisdiction. And then step 3 is the U.S. Supreme Court. There are 9 members of the U.S. Supreme Court. They will generally hear things on appeal. Associated with this is what's called the writ of certiorari, where the Supreme Court will issue this writ if they want to hear a case. And 4 justices need to agree to hear a case, and this is called the rule of 4. So ultimately, it's going to take 4 justices to agree to hear a case, and then it's going to take 5, or the majority of the 9 justices, to make a decision on the case. So let's take a look at different types of opinions that the Supreme Court can write up. So an opinion is written, a decision. It often takes months. There's many drafts. You have a majority opinion, and the group of justices in the majority opinion must draft an opinion setting out the reasons for their decision. You can have a concurring opinion. This is for justices who agree with the majority opinion, but they have different reasons for agreeing to the outcome of the majority opinion, and so they're going to give their reasons. That's the concurring opinion. And you have the dissenting opinion, which includes justices who disagree with the opinion, and they write their side. So they disagree with the decision, and they're going to write about why they disagree with that decision. That is called the dissenting opinion. It's important to understand that these different opinions set what's called precedent. They set an example to be followed later. So legal ideas that have been previously established by the Supreme Court need to be applied to future cases. This is called precedent. Supreme Court decisions will set precedent. Now, once the court makes a decision, this decision has to be implemented, and this can be sometimes a difficult part of a Supreme Court decision and actually creating change. So for example, Andrew Jackson one time said, "John Marshall has rendered his decision, now let him enforce it." And of course, it's difficult for the Supreme Court, since they don't actually have the power to enforce law, to do this. Andrew Jackson, of course, as a president, is a member of the executive branch and can execute the law. Chief Justice Earl Warren said that schools needed to be desegregated at deliberate speed. Yet, 10 years after Brown versus Board of Education, only 1% of Southern schools were desegregated. So courts must rely on branches, states, officials to enforce its ruling. So this is a big weakness, because courts have difficulty implementing the policies that they decide on. All right, we're going to go ahead and move on to the next video.